Hi everyone, my name is Sukhbir Singh. Hope you are all well. Today me and my team going to speak on topic impact of statutory. Today I will be discussing the impact of statutory law on the principle of freedom of contract, specifically focusing on the Australian Consumer Law or ACL. Traditionally, freedom of contract has been a cornerstone of contract law, allowing businesses and individuals to negotiate and agree upon terms freely. However, statutory laws like the ACL have introduced regulations to ensure fairness in commercial transactions and protect consumers. These regulations include provisions on unfair contract terms and implied terms, which have significantly influenced the landscape of contractual freedom. Traditional contract law and freedom of contract. In a traditional contract law, especially within common law systems like Australia's freedom of contract is highly valued. It's based on the idea that parties should have the autonomy to structure their agreements without external interference. Classical contract law emphasizes that all competent parties voluntarily agree in a legal manner, supported by a valid consideration. Courts typically uphold the terms of written contracts, presuming that parties have equal bargaining power. If there's an imbalance or potential unfairness, unless the terms are illegal or violate public policy. Statutory law and consumer protection. The role of the ACL. Recognizing the limitations of traditional contract law in protecting consumers, the Australian government introduced the Australian Consumer Law or ACL as part of the Competition and Consumer Act 2010. The ACL provides a comprehensive regulatory framework that applies to all goods and services sold within Australia. Its primary aim is to balance the need for contractual freedom with the necessity of protecting consumers and small businesses from unfair practices.
Hi everyone, my name is Ramandeep Singh. I am discussing about the unfair contract terms under Part 2 and 3 of the ACL. A contract term is considered unfair if it is causes a significant imbalance in the parties' rights and obligations, would cause financial or other detriments to a consumer if relied upon, and is not reasonably necessary to protect the legitimate interest of the party advantaged by the terms. This is the particularly relevant in the standard form contracts, where consumers have little to no opportunity to negotiate terms. If a term is deemed unfair, it can be declared void, limiting the contractual freedom of businesses to impose such terms. The implied term under the ACL. The ACL also introduced certain non-excludable guarantees into contracts for the sales of goods and services, further limiting contractual freedom. Section 54 to 59 mandates that goods must be acceptable quality, match their descriptions, and be fit to any disclosed purpose. Similarly, service must be provided with the due care and skills and within a reasonable time. Importantly, businesses cannot exclude or limit these guarantees in consumer contracts, even if their contracts include clauses attempting to do so. Consumer protection against misleading and deceptive conduct. Another crucial provision in Section 18 of the ACL, which prohibits misleading or deceptive conduct in trade or commerce, regardless of how freely a contract was negotiated. It can be void or lead to penalties if it involves any form of misleading or deceptive conduct. This places a duty or on businesses to ensure all statements related to a contract are accurate, representing another significant limitation on contractual freedom to protect consumers.
My name is Komalpreet Singh. Today I am talking about business adaptation to the ACL. In response to these stationary regulations, business across various sectors have had to adapt their practice. It's essential for business to draft contracts carefully, ensuring no unfair terms are included. Compliance with stationary guarantees regarding the quality and fitness of goods and services is crucial. By doing so, business can avoid legal pitfalls associated with non-compliance and maintain good relationship with consumers. Legal compliance and contract drafting. Meticulous contract drafting has become wider, especially for standards from contract prevent in industries like retail. Insurance, telecommunication, and finance legal teams play a key role in reviewing contract terms to ensure they comply with the ACLs. They must expressly acknowledge stationary guarantees and eliminate any terms that could be deemed unfair, thereby aligning contractual practice with the legal requirements. Sector-specific response. Different sectors have faced unique challenges in adapting to the ACL. For instance, the telecommunications industry has had to reasons and remove terms related to high termination fees, which the ACL considers unfair. In the rental sector, business must ensure their refund policies align with the stationary countries. Similarly, the finance and insurance sector have seen an increased emphasis on temporary and fairness to comply with the ACL.
My name is Arshdeep Singh, baidwan, and today I talk about to manage the risks associated with non-compliance businesses are investing more in compliance program and risk management solutions. Tools like internal adults of contracts and staff training have become essential. These programs help identify and rectify unfair terms proactively, ensures that contracts are legally sound and reducing the risk of penalties. In conclusion, while the Australian consumer law imposes limitations on the freedom of contract, it plays a crucial role in promoting fairness and protecting consumer in commercial transactions. Business must remain transparent and comply with these statutory regulations within their contracts. By adopting robust strategies and being mindful of legal obligations, business can successfully navigate the complexities of contract law, maintaining integrity and fostering positive relation with consumer. Thank you.